You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The United States privacy model is best understood as a sectoral patchwork. At the federal level, Congress has enacted targeted statutes addressing specific industries or types of personal data, such as health, finance, children, and education. These laws establish baseline protections but leave significant gaps that states have increasingly filled through both comprehensive privacy statutes and sector overlays. Unlike the European Union's unified approach, the U.S. requires organizations to map multiple, overlapping obligations depending on the context of their data use. For exam candidates, the key concept is coexistence. Federal frameworks establish minimum standards, but states often expand, refine, or create entirely new obligations. Scenarios may test whether federal privacy law preempts all state action, with the correct recognition being no preemption is selective, and states often maintain broad parallel authority. Recognizing this underscores that U.S. compliance depends on harmonizing federal baselines with state-layered obligations across industries. The Federal Trade Commission serves as the primary federal privacy regulator under its Section 5 authority to police unfair or deceptive acts and practices. This broad mandate allows the FTC to challenge companies for misrepresenting privacy practices, failing to implement reasonable security, or engaging in unfair conduct. Enforcement usually results in consent decrees imposing multi-year obligations, such as audits, risk assessments, and program reporting. For exam purposes, the key concept is baseline consumer protection. Scenarios may test whether the FTC has jurisdiction over nonprofits or common carriers, with the correct recognition being no, these sectors are outside its authority. Recognizing the FTC's role highlights that, while it lacks a comprehensive federal privacy law to enforce, its consumer protection powers have become a flexible tool for addressing gaps, setting expectations for reasonable data practices across industries. The Children's Online Privacy Protection Act imposes strict requirements on operators of websites and services directed to children under 13 or those knowingly collecting data from children. Its hallmark obligation is verifiable parental consent prior to collecting, using, or disclosing a child's personal information. Operators must also provide clear notices, limit collection to what is reasonably necessary, and allow parents to review and delete information. For exam candidates, the key concept is consent mechanics. Consent must be verifiable, such as through signed forms, government ID checks, or payment verification, not simply a pre-checked box. Scenarios may test whether COPPA applies to teens over 13, with the correct recognition being no, though states like California extend protections. Recognizing this emphasizes that federal baselines for children's privacy are narrow, leaving states to expand protections for adolescents through emerging statutes. The Health Insurance Portability and Accountability Act Privacy Rule provides the federal foundation for protecting health information. It applies to covered entities, health plans, health care providers, and clearinghouses, and their business associates. The privacy rule limits uses and disclosures of protected health information, grants individuals rights of access and amendment, and requires minimum necessary principles in data handling. For exam candidates, the key concept is scope. HIPAA does not cover all health-related data, only that held by regulated entities. Scenarios may test whether fitness app data is automatically subject to HIPAA, with the correct recognition being no, it falls outside unless a HIPAA entity is involved. Recognizing this underscores that HIPAA establishes a baseline, but gaps remain for consumer health data, which states have begun regulating independently. The HIPAA security rule complements the privacy rule by establishing administrative, physical, and technical safeguards for electronic, protected health information. Covered entities and business associates must conduct risk analyses, implement access controls, maintain audit logs, train staff, and protect against reasonably anticipated threats. For exam purposes, the key concept is safeguard categories. Scenarios may test whether encryption is explicitly mandated, with the correct recognition being no. It is an addressable safeguard, requiring documented decisions. Recognizing this emphasizes that HIPAA's security rule is risk-based and flexible, but regulators expect documented justifications and reasonable implementations. Compliance requires both structured governance and technical controls, reinforced by enforcement actions from the Department of Health and Human Services Office for Civil Rights. The Health Information Technology for Economic and Clinical Health Act expanded HIPAA enforcement and created the first federal breach notification requirements for health data. Covered entities and business associates must notify affected individuals, HHS, and sometimes the media when unsecured protected health information is breached. HITECH also increased penalties and strengthened enforcement by empowering state attorneys general. For exam candidates, the key concept is notification triggers. Scenarios may test whether all incidents require notification, with the correct recognition being no only those involving unsecured data that compromise privacy or security. Recognizing this highlights that HITECH linked HIPAA obligations to transparency and enforcement, underscoring breach response as a cornerstone of modern privacy compliance. The 21st Century Cures Act advanced interoperability by requiring electronic health records to support secure data exchange, and by prohibiting information blocking. Healthcare providers, developers, and exchanges must make information available to patients and authorized parties without unreasonable barriers. For exam purposes, the key concept is access rights. Scenarios may test whether providers can delay release of records to avoid competition, with the correct recognition being no such practices may constitute unlawful information blocking. Recognizing this highlights the interplay between privacy and access. Modern frameworks require balancing confidentiality with portability, ensuring patients can access and share their health information freely. The confidentiality of substance use disorder patient records rule, codified at 42 CFR Part 2, imposes stricter protections than HIPAA for records related to treatment of substance use disorders. Disclosures generally require patient consent, with limited exceptions for emergencies or research. The heightened safeguards reflect the stigma and risks associated with these records. For exam candidates, the key concept is heightened protection. Scenarios may test whether Part 2 data can be shared under HIPAA treatment exceptions, with the correct recognition being no Part 2 imposes stricter rules. Recognizing this highlights how federal privacy laws vary within sectors, requiring layered compliance when data categories overlap. The Fair Credit Reporting Act governs consumer reporting agencies, mandating accuracy, permissible purposes for disclosures, and access rights for individuals. Consumers can dispute inaccuracies, and agencies must investigate and correct errors. The Fair and Accurate Credit Transactions Act amended FCRA to address identity theft, requiring fraud alerts, truncation of credit card numbers, and red flags guidelines for financial institutions. For exam purposes, the key concept is permissible purpose. Scenarios may test whether employers can access credit reports without consent, with the correct recognition being no FCRA requires explicit authorization. Recognizing these laws underscores that financial privacy in the U.S. rests on statutory frameworks ensuring both accuracy and security in credit reporting and identity protection. The Gramm-Leach-Bliley Act requires financial institutions to provide privacy notices explaining data sharing practices and opt-out options for non-affiliated disclosures. Its safeguards rule compels institutions to implement security programs including risk assessments, staff training, and oversight of service providers. The Identity Theft Red Flags Rule, issued jointly by regulators, requires covered entities to maintain programs to detect, prevent, and mitigate identity theft. For exam purposes, the key concept is layered obligations. Scenarios may test whether GLBA allows unlimited sharing with affiliates, with the correct recognition being yes, opt-outs apply only to non-affiliates. Recognizing this highlights how sectoral laws balance consumer choice with institutional flexibility, requiring compliance programs to incorporate both notice and safeguard requirements. The Dodd-Frank Act created the Consumer Financial Protection Bureau, consolidating oversight of financial privacy practices. The CFPB enforces FCRA, GLBA, and other statutes, issuing regulations and pursuing enforcement actions. For exam candidates, the key concept is supervisory consolidation. Scenarios may test whether the FTC continues to oversee financial privacy, with the correct recognition being no CFPB has primary authority in this sector. Recognizing this underscores that federal oversight is dynamic, with agencies shifting roles as new statutes centralize authority. The CFPB has become a critical player in shaping consumer financial privacy through both supervision and enforcement. The Family Educational Rights and Privacy Act governs student education records, granting parents and eligible students rights of access, amendment, and control over disclosure. Schools must obtain consent before releasing records, with limited exceptions for legitimate educational interests. For exam purposes, the key concept is access and consent. Scenarios may test whether FERPA applies to private tutoring companies, with the correct recognition being no, it applies only to federally funded institutions. Recognizing this highlights FERPA's limits, as educational technology vendors may fall outside unless state laws expand coverage, creating gaps that states increasingly address. Telecommunications and marketing statutes establish additional baselines. The Telemarketing Sales Rule and the Telephone Consumer Protection Act regulate consent for calls and texts, including do not call lists and autodialer restrictions. CAN-SPAM governs email marketing, requiring opt-outs and accurate headers. The Junk Fax Prevention Act limits unsolicited faxes, while the Cable Act and Video Privacy Protection Act restrict disclosure of viewing histories. The Driver's Privacy Protection Act limits disclosure of motor vehicle records. For exam purposes, the key concept is channel-specific regulation. Scenarios may test whether TCPA covers marketing text messages, with the correct recognition being yes. Recognizing this underscores that U.S. federal privacy law is fragmented across communication channels, each with distinct consent and disclosure standards. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Preemption boundaries define how federal sectoral laws interact with state statutes. In some areas, federal law expressly preempts state action, such as certain provisions under FCRA ensuring uniform national standards. In others, states are free to add protections, as seen in health privacy laws that go beyond HIPAA. This coexistence creates layered obligations. Compliance with federal rules may satisfy minimum requirements, but state laws can impose stricter duties. For exam candidates, the key concept is coexistence rather than displacement. Scenarios may test whether HIPAA prevents states from enacting stricter health privacy rules, with the correct recognition being no. Recognizing this underscores that organizations must read federal laws as baselines and anticipate state overlays, building compliance programs that harmonize requirements and adapt to jurisdictional variations rather than assuming federal supremacy eliminates state obligations. State attorneys general play a complementary role in enforcing sector-specific privacy. Many federal statutes, such as HIPAA and HITECH, empower state AGs to pursue violations independently, often in coordination with federal agencies. Even where no delegation exists, state AGs can act under general consumer protection laws to pursue unfair or deceptive practices. This creates a dual enforcement model. Federal regulators set standards and pursue systemic violations, while state AGs target local harms and hold entities accountable to state residents. For exam candidates, the key lesson is dual authority. Scenarios may test whether only federal agencies enforce HIPAA, with the correct recognition being no state AGs also act. Recognizing this highlights that enforcement pressure comes from multiple directions, making diligence and defensibility crucial at both state and federal levels. California's Privacy Protection Agency illustrates the rise of dedicated state-level regulators with authority rivaling federal agencies. The CPPA enforces the CPRA, issues regulations, and conducts audits, positioning California as a leader in shaping consumer privacy. Its authority intersects with federal priorities, such as online marketing disclosures and sensitive data protections, creating an additional compliance layer for entities subject to both regimes. For exam purposes, the key concept is parallel oversight. Scenarios may test whether CPPA enforcement is subordinate to the FTC, with the correct recognition being no, it operates independently. Recognizing this underscores that states like California increasingly act as privacy laboratories, adding comprehensive laws that complement and sometimes surpass federal frameworks, influencing compliance nationwide. State health data laws provide protections beyond HIPAA's limited scope. HIPAA applies only to covered entities and business associates, leaving gaps for consumer health apps, fitness trackers, and wellness platforms. States like Washington and Nevada have begun regulating these spaces directly, imposing consent, disclosure, and retention rules. For exam candidates, the key concept is gap filling. Scenarios may test whether HIPAA covers all health data, with the correct recognition being no. Recognizing this highlights how states respond to evolving technologies and market trends, extending health privacy protections to data holders excluded from federal oversight, and requiring companies to navigate overlapping obligations when handling consumer-generated health information. State financial privacy provisions also vary in scope and exemptions compared to federal GLBA baselines. While GLBA requires privacy notices and opt-outs for non-affiliated sharing, some states, such as California, impose stricter consumer rights or broader coverage of financial service providers. Other states regulate insurance privacy specifically, adding rules for medical and claims data. For exam purposes, the key concept is variability. Scenarios may test whether GLBA opt-outs preclude state-level financial privacy rights, with the correct recognition being no. Recognizing this illustrates that financial institutions must track both federal and state-specific obligations, tailoring notices, opt-outs, and security safeguards to address both national standards and jurisdictional variations across the United States. State education privacy overlays increasingly address gaps not covered by FERPA. While FERPA regulates federally funded educational institutions, it does not fully govern educational technology vendors. States like California and Colorado impose specific rules on edtech providers, requiring contracts with schools, limiting secondary uses, and mandating security safeguards. For exam candidates, the key concept is vendor accountability. Scenarios may test whether FERPA alone regulates data collected by online learning platforms, with the correct recognition being no. Recognizing this highlights how states supplement federal frameworks by protecting student data in modern contexts, ensuring that new actors in the education ecosystem are subject to enforceable privacy obligations even when federal statutes do not apply. Telemarketing and text messaging obligations at the state level add consent and registration layers on top of federal rules like TCPA and the telemarketing sales rule. States may establish stricter do-not-call lists, require in-state registration of telemarketers, or impose narrower consent definitions for robocalls and texts. For exam purposes, the key concept is stricter consent. Scenarios may test whether TCPA compliance alone suffices in all states, with the correct recognition being no. Recognizing this underscores that organizations must manage multiple frameworks simultaneously, layering state requirements onto federal baselines, and configuring communication systems to honor both national and local restrictions in marketing outreach. Biometric privacy has emerged as a state-driven frontier, with laws like Illinois' Biometric Information Privacy Act requiring informed consent, public disclosures, and defined retention limits for biometric identifiers. No federal equivalent exists. Litigation under BIPA has been significant, with class actions driving enforcement. For exam candidates, the key concept is novel state leadership. Scenarios may test whether federal law governs biometric retention, with the correct recognition being no. Recognizing this emphasizes that state statutes are pioneering biometric governance, forcing companies to implement policies, consent flows, and retention schedules specifically for biometric data, regardless of broader federal frameworks. State comprehensive privacy laws provide generalized rights that cross industry boundaries. Laws like the CPRA, Colorado Privacy Act, and Virginia CDPA grant rights of access, deletion, correction, portability, and opt-outs for sale, sharing, or profiling. These rights apply broadly, unlike sectoral federal laws. For exam purposes, the key concept is universality. Scenarios may test whether federal sector laws eliminate the need to comply with state comprehensive statutes, with the correct recognition being no. Recognizing this highlights that organizations must integrate state-level rights programs into compliance frameworks, creating consumer-facing processes that can handle broad requests across sectors. Data broker registration statutes have emerged in states like Vermont and California, requiring companies that sell or share personal data they did not collect directly from consumers to register and disclose practices. These rules increase transparency in an opaque industry and impose enforcement risks for non-compliance. For exam candidates, the key concept is transparency for indirect collection. Scenarios may test whether federal law mandates data broker registration, with the correct recognition being no. Recognizing this underscores how states are filling transparency gaps, holding data intermediaries accountable to public registries and disclosure obligations. Cookie and online tracking regulations increasingly appear in state laws, requiring disclosures, opt-out mechanisms, or consent for certain practices. California, for example, treats targeted advertising as a form of data sharing, requiring opt-out options. Colorado and Connecticut mandate recognition of universal opt-out signals like global privacy control. For exam purposes, the key concept is online applicability. Scenarios may test whether federal law mandates universal opt-out recognition, with the correct recognition being no. It is state-driven. Recognizing this highlights that compliance programs must adapt to multiple state-level online tracking rules, embedding preference signal recognition and cookie governance across digital properties. State enforcement mechanics vary widely. Some laws include cure periods allowing violations to be remedied before penalties attach, while others impose immediate fines. Penalty amounts differ, and states increasingly conduct proactive audits rather than relying only on complaints. For exam candidates, the key concept is enforcement diversity. Scenarios may test whether all states require cure opportunities, with the correct recognition being no. Recognizing this highlights that compliance teams must track enforcement structures by jurisdiction, building proactive monitoring and audit readiness into programs to manage diverse state-level risk exposures. Incident and breach notification laws at the state level create harmonization challenges with federal sectoral rules. HIPAA requires notification within 60 days, while state laws impose varying timelines, often shorter, and apply to broader data categories. A single incident may trigger overlapping obligations across dozens of states and federal regulators. For exam candidates, the key concept is multi-jurisdiction notification. Scenarios may test whether HIPAA compliance alone satisfies state breach laws, with the correct recognition being no. Recognizing this highlights the operational complexity of harmonizing sectoral and state obligations, requiring decision frameworks, pre-drafted notices, and parallel communication strategies to avoid missed deadlines. Compliance program design must unify these multiple obligations into a coherent framework. Best practices include adopting federal sector requirements as baselines, then layering state-specific obligations into policies, notices, and consumer rights processes. Maintaining a central privacy office, inventory, and assessment pipeline allows organizations to adapt flexibly to evolving laws. For exam candidates, the key concept is layered integration. Scenarios may test whether federal compliance eliminates the need for state programs, with the correct recognition being no. Recognizing this highlights that organizations must design compliance systems that harmonize sectoral, federal, and state obligations, ensuring accountability across the fragmented U.S. privacy landscape. By understanding federal baselines and layering state-specific duties, organizations can build defensible, resilient privacy programs. For exam candidates, the synthesis is clear. Compliance in the U.S. demands harmonizing sectoral federal rules with increasingly comprehensive and innovative state frameworks. Recognizing this highlights that Domain 2 is defined by interplay, not exclusivity. Federal baselines provide structure, but state innovation drives expansion, requiring programs to be flexible, layered, and auditable across all jurisdictions. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.